Today, June 30, 2026, a federal high court judge in Abuja granted Omoyele Sowore bail. That sounds like good news. Here is what the bail actually requires. 200 million naira, 2 sureties. One of those sureties must be a traditional ruler from his community, and Sowore must surrender his international passport to the court immediately. For posting on X that Tinubu is a criminal. While everyone is debating whether the bail conditions are too harsh, nobody is asking the question that exposes the entire legal strategy. In a defamation case, truth is an absolute defense, which means if this case actually goes to trial, the government must prove in open court that the statement Sowore made is factually false. So why is the DSS spending this much institutional energy on bail mechanics rather than racing to trial? That question tells you everything about what this case is really for. If you're new here, this channel exists for one reason: to give Nigerians the political analysis mainstream media want. Hit subscribe and stay with me. This gets deeper. The case originates in social media posts Sowore published on his X and Facebook accounts, in which he referred to President Bola Tinubu as a criminal. The exact posts and their dates have not been fully specified in public court documents available to this production. They were reportedly made in 2025. The DSS filed cybercrime and criminal defamation charges against Sowore before the Federal High Court in Abuja in December 2025. He was arraigned, pleaded not guilty, and was initially granted bail on self-recognition, the most liberal possible bail condition, requiring no money and no surety. June 16, 2026, Sowore failed to appear in court for the continuation of his trial. Justice Mohammed Umar, acting on a DSS application, revoked his bail and issued a bench warrant for his arrest. June 17, 2026, Sowore's lawyers filed a motion dated June 17, formally filed June 19, seeking 12 reliefs, including setting aside the bail revocation, vacating the bench warrant, and restoring the original bail conditions. They invoked sections 35(4), 36(1), and 66(a) and (b) of the 1999 Constitution and sections 169 and 352 of the Administration of Criminal Justice Act 2015. June 23, 2026, Sowore was arrested following the bench warrant and remanded at Kuje Correctional Center. June 24, 2026, Justice Umar heard the bail restoration application, rejected an oral request to release Sowore to his lawyers pending the ruling, and fixed June 30 for a formal ruling. The judge noted Sowore's reported health challenges were acknowledged, but that a considered ruling required full review of all processes. June 30, 2026, today, Justice Umar delivered his ruling restoring bail on the following terms. 2 sureties, each in the sum of 200 million naira. 1 must be a traditional ruler from Sowore's community. 1 must own landed property in the FCT. And Sowore must deposit his international passport with the Deputy Chief Registrar of the court. Sowore is next due in court on July 6, 2026, when he is expected to open his defense. Omoyele Sowore, 52, is a journalist, publisher, and political activist. He is the founder and publisher of Sahara Reporters, a Nigerian-American online news platform that has broken multiple major investigative stories involving Nigerian government officials. He is the presidential candidate of the African Action Congress, AAC. He ran in the 2019 presidential election. He was arrested in August 2019 under the Buhari administration on charges of treason for calling a revolution, was detained for months, and was the subject of sustained international attention from press freedom organizations and U.S. congressional members. He is a U.S. permanent resident based in New York. The current charges filed under the Tinubu administration are structurally different from the 2019 treason charge. They are filed under the Cybercrime Act rather than the Treason Act, and the alleged conduct is a social media post rather than a call to overthrow the government. But the pattern, DSS prosecution of a political activist who is also a journalist critical of the president, is consistent across administrations. The Take It Back movement, the civic organization connected to Sowore's activism, issued an immediate statement signed by National Coordinator Juwon Sayalu, describing the bail conditions as punitive, oppressive, and excessive, and arguing they, quote, amount to punishment before trial, end quote, and were, quote, designed to frustrate and intimidate the activist, end quote. The movement specifically faulted the traditional ruler requirement and the 200 million naira figure as conditions with no proportionate relationship to the alleged offense. Sowore himself, speaking outside the court after the ruling, said, quote, "There is no boss on earth that can stop this revolution. We warned them, but they would not listen. But now it appears a little bit of common sense is returning to them, and as a result, I was granted bail," end quote. Institutions involved. The Federal High Court Abuja, Justice Mohammed Umar, the presiding judge on this case. The Department of State Services, DSS, the prosecuting body represented by San Akinlolu Kehinde. Sowore's legal team, led by Senior Advocate Adeyinka Olumide-Fusika, San, with R.O. Adakole and C.S. Etonyeku appearing in court. Kuje Correctional Center, where Sowore was remanded from June 23rd to today. The Take It Back movement, Sowore's associated civic organization, which has formally reacted to the bail conditions. The AAC, African Action Congress, Sowore's political party, whose presidential candidate is the defendant. Under the Administration of Criminal Justice Act 2015, ACJA, and the 1999 Constitution, the primary purpose of bail is to ensure the defendant's attendance at trial, not to punish, not to incapacitate, and not to make a political statement about the severity of the alleged offense. The factors a court must consider in setting bail conditions under the ACJA include the likelihood of the defendant appearing for trial, the nature and gravity of the offense, the criminal antecedents of the defendant, the strength of the evidence, and any exceptional circumstances. Against those factors, Sowore appeared at all previous hearings until the June 16th absence. He has no prior conviction. The alleged offense is a social media post, not violence or financial crime. He is a public figure with a known address in both Nigeria and the United States. The ACJA framework does not require financial conditions to be set at a level that is practically impossible to meet. It requires conditions proportionate to the purpose of ensuring appearance. The N200 million figure is where the proportionality argument collapses for Sowore's lawyers. N200 million is approximately USD 130,000 at current rates, a significant sum that exceeds most Nigerians' annual income by a factor of hundreds. For a cybercrime/defamation case involving a social media post, this is orders of magnitude above what comparable cases in Nigerian courts have required. It functions less as a surety for appearance and more as a financial barrier to freedom.
The traditional ruler surety condition is the more analytically significant of the two requirements, and the one most likely to cause the longest practical delay. Traditional rulers in Nigeria are formally recognized by and under the administrative authority of state governors. A traditional ruler from Sowore's community in Edo State would need to be willing to put his stool and his reputation behind a man the federal government is prosecuting for defaming the president. The practical problem is not the law. The law does not prohibit a traditional ruler from serving as a surety. The practical problem is the political pressure, formal or informal, that makes a traditional ruler's willingness to serve in that capacity uncertain. If no traditional ruler is willing, or if the search for one is protracted, Sowore's bail, formally granted, becomes practically unenforceable until the condition is met. He would remain in Kuje during the perfection period. Section 24 of the Cybercrime Prohibition Prevention Act 2015 criminalizes messages transmitted through computer systems that are grossly offensive, pornographic, or of an indecent, obscene, or menacing character, or that are false for the purpose of causing annoyance, inconvenience, danger, obstruction, insult, injury, criminal intimidation, enmity, hatred, ill will, or needless anxiety to another. The DSS appears to be relying on the false and insult provisions. Two legal problems with this application. First, the characterization, criminal, applied to a public figure is a value judgment, not a verifiable fact in the way that a false statement of fact is verifiable. Most serious legal systems distinguish between statements of fact and statements of opinion in defamation law, with opinions receiving broader protection. Second, whether calling a president a criminal constitutes criminal insult under the statute is a question that Nigerian courts have not definitively settled. The NBA and multiple constitutional lawyers have publicly questioned whether Section 24 in this application is consistent with Section 39 of the Constitution, which guarantees freedom of expression. The most direct beneficiary of bail conditions that are practically difficult to perfect is a government that wants Sowore's civic and media activity disrupted without producing the international optics of an outright refusal to grant bail. A Sowore who is in Kuje cannot run Sahara reporters. A Sowore who is focused on sourcing a traditional ruler surety and 200 million naira is not focused on investigative reporting. The bail conditions accomplish through judicial process what a detention order would accomplish more visibly and more controversially. This is the institutional logic that the Take It Back movement's characterization of the conditions as punishment before trial correctly identifies. Even if the court's internal reasoning for setting these conditions is more procedurally grounded than politically motivated, the practical effect is punitive, and the political beneficiary is the administration whose president Sowore described as a criminal. The prosecution has consistently focused on bail mechanics, opposing the restoration of original bail conditions, opposing Sowore's temporary release to his lawyers, urging stricter terms, rather than demonstrating urgency to proceed to a full defamation trial. This is strategically rational for the government if the preferred outcome is prolonged disruption of Sowore's activities rather than a verdict. A trial requires producing evidence. A trial where Sowore mounts a truth defense requires the government to prove Tinubu is not a criminal. The bill mechanic strategy avoids that exposure while keeping Sowore in a state of legal preoccupation. The Nigerian Bar Association and the broader legal profession are watching whether judicial bail conditions in politically sensitive cases are calibrated to legal principles or to political outcomes. If the pattern of escalating bail conditions in activist cases becomes normalized, self-recognition in December and 200 million naira in June, it creates a template that any future government can apply to any inconvenient journalist or activist. The NBA's institutional credibility as a check on executive use of judicial process is at stake in how it responds to the Take It Back movement's characterization of these conditions. Justice Umar is also in a position of institutional exposure. His June 16 bail revocation, made on a DSS oral application without full hearing, and now his June 30th stricter than original conditions, will be scrutinized by constitutional lawyers and media organizations as a documented set of judicial choices in a case that has become a test of judicial independence in the Tinubu era. Sowore is the AAC's presidential candidate. An AAC presidential candidate who is in and out of Kuje Correctional Center during his party's pre-campaign period cannot build the national platform he would need to be a meaningful 2027 contestant. Whether the prosecution is designed with this in mind, or whether the timing is coincidental, the electoral effect is the same. Sowore's AAC platform, which draws on significant youth and civil society energy, is disrupted by legal preoccupation regardless of what the court ultimately decides. Now, if what I just told you surprises you, drop a comment below. I want to know what you think before we get to the part that changes everything.
The Sowore prosecution under Section 24 of the Cybercrime Act for a social media post is not the first such application in Nigeria, but it is the highest profile one involving a sitting president and a named political critic. If the prosecution succeeds, if Sowore is convicted for calling Tinubu a criminal on social media, Section 24 becomes the confirmed legal basis for prosecuting political opinion expressed online. Every Nigerian with a Twitter, Facebook, or WhatsApp account who has described any public official in negative terms is, in principle, within the same legal perimeter. The chilling effect on political speech online, the most accessible form of political expression for millions of Nigerians who cannot afford broadcast media or print, is the most significant national implication of this prosecution, independent of what happens to Sowore personally. Nigeria's Cybercrime Act was legislated primarily to address digital financial crimes, hacking, advance fee fraud, identity theft, and the infrastructure of internet-enabled crime. Its Section 24 extension to cover online expression was controversial from the moment of passage. Using it to prosecute political speech specifically is a documented expansion that is separate from any individual case's merits. The national implication is that a law designed to protect citizens from digital criminals is being applied to criminalize citizens for digital speech, a category error with long-term consequences for how Nigeria regulates the internet. Sowore's counsel reported health challenges during his remand period. The court noted but did not act on this concern in the June 24 hearing. If Sowore's health deteriorates during the bail perfection period, before the 200 million naira conditions are met and before he is formally released, the institutional responsibility for that deterioration falls on the correctional system, on the prosecution that opposed his temporary release, and on the court that declined to release him pending the ruling. Kuje Correctional Center is a notoriously overcrowded facility. It is the same facility where Nnamdi Kanu's location is under question. The conditions of pretrial detention in Kuje are a documented human rights concern independent of any specific case.
Sowore's 2019 arrest under the Buhari administration attracted specific attention from U.S. congressional members, including letters sent to the Nigerian government calling for his release, citing both his U.S. residency and press freedom concerns. The Committee to Protect Journalists, CPJ, and Reporters Without Borders, RSF, documented his 2019 case extensively. Both organizations monitor Nigeria's press freedom environment actively. The current prosecution, involving a US-based Nigerian journalist prosecuted for social media posts, places Nigeria again in the category of governments that CPJ and RSF characterize as press freedom violators. The U.S. State Department's annual country reports on human rights practices specifically monitors cybercrime law applications that restrict free expression. Nigeria's Section 24 prosecutions are a documented category in those reports. Whether the current Sowore prosecution prompts a formal State Department comment depends on the level of congressional and civil society pressure generated, both of which are functions of diaspora community engagement. The UN Special Rapporteur on the Promotion and Protection of the Right to Freedom of Opinion and Expression has specifically and publicly flagged Nigeria's Cybercrime Act Section 24 as incompatible with international human rights standards, citing its overly broad language and potential for misuse against political expression. Nigeria is a signatory to the International Covenant on Civil and Political Rights, ICCPR, whose Article 19 protects freedom of expression, including political opinion. The current prosecution places the Nigerian government in direct tension with this treaty obligation, and the June 30 bail conditions, which function as a practical deterrent to free expression, compound rather than resolve that tension. For Nigerian diaspora communities in the UK and US, the Sowore case carries a specific resonance that extends beyond his individual circumstances. He is US-based. He runs a diaspora-facing media platform. His case is about what Nigerians can legally say about their government on the internet, an activity that diaspora Nigerians engage in constantly from abroad, including through Sahara Reporters itself. If a Nigerian who publishes critical political content online from outside Nigeria faces criminal prosecution when he returns home, the chilling effect extends to the diaspora community's willingness to fund, write for, or share the work of independent Nigerian media platforms. The practical question for diaspora Nigerians in the UK and US: if you have shared, liked, or commented on Nigerian political content describing Tinubu or any public official in negative terms, are you within the legal perimeter of Section 24? The extraterritorial reach of the Cybercrime Act has not been tested in this context, but the question itself, raised by a prosecution of this visibility, is the chilling effect the law's critics warned about.
The most defensible version of the prosecution's position is this: Sowore failed to appear in court on June 16, a failure the defense has not publicly and convincingly explained, and which the prosecution characterized as a demonstrated disregard for the court's authority. In any judicial system, failure to appear for trial is a serious matter that justifies both bail revocation and stricter conditions on any subsequent grant of bail. The court is entitled to impose conditions that reduce the risk of a second non-appearance. A financial bond and passport surrender are standard tools for managing flight risk in cases where a defendant has demonstrated they may not appear voluntarily. On the charges themselves, calling a head of state a criminal on a public social media platform is not simply a political opinion, it is a statement of fact about criminal conduct that, if false and published maliciously, can cause genuine reputational harm. Every democratic society balances free expression against protection from defamation. Nigeria's legal framework provides that balance. Sowore's case is its test, not its perversion. That is the prosecution's strongest argument. Misconceptions in public discourse. 1. Sowore is being prosecuted for having an opinion about Tinubu. More precisely, he is being prosecuted for a specific published statement characterizing Tinubu as a criminal, a statement of alleged fact, not merely an opinion. The legal distinction between opinion and fact matters for how a truth defense would be structured and for what the court is actually required to adjudicate. 2. Bail being granted means he is free. Not yet. Bail granted but not perfected leaves the defendant in custody until all conditions are met. Finding a traditional ruler willing to stand surety, meeting the 200 million naira bond, and processing the passport surrender are all conditions precedent to actual release. He could remain in Kuje for days or weeks while these are being arranged. 3. This is only about Sowore. It is also about Section 24 of the Cybercrime Act, about the scope of defamation law as applied to political expression, and about the template this prosecution is establishing for how future governments can respond to critical online speech. Sowore is the current defendant. The legal precedent being set out lasts him. Nigeria's core national interest in this case is in the answer to one question: does Section 24 of the Cybercrime Act, as applied to political expression online, survive constitutional scrutiny under Section 39's guarantee of free expression, or does it not? That question has not been answered definitively by any Nigerian court at the appellate level. The Sowore prosecution will generate an answer, eventually, through the appellate process, and that answer will determine whether Nigeria's internet freedom environment is, in law, consistent with its constitutional commitments, or whether online political speech in Nigeria operates under a statutory threat that the Constitution did not intend and cannot sustain. For the Southwest specifically, whose civic and journalistic culture has historically been among the most vibrant and most critical of federal power in Nigeria, a Section 24 regime that can prosecute political opinion online is a direct threat to the institutional culture that Southwest political credibility is built on. The independent journalism, the civic commentary, the online political debate that flows through Southwest communities, all of it sits within the legal perimeter that the Sowore prosecution is currently drawing. Whether Southwest legal and civic institutions actively contest that perimeter or passively accept it is the specific regional accountability question this case generates.
The most defensible version of the prosecution's position is this: Sowore failed to appear in court on June 16,
a failure the defense has not publicly and convincingly explained, and which the prosecution characterized as a demonstrated disregard for the court's authority. In any judicial system, failure to appear for trial is a serious matter that justifies both bail revocation and stricter conditions on any subsequent grant of bail. The court is entitled to impose conditions that reduce the risk of a second non-appearance. A financial bond and passport surrender are standard tools for managing flight risk in cases where a defendant has demonstrated they may not appear voluntarily. On the charges themselves, calling a head of state a criminal on a public social media platform is not simply a political opinion. It is a statement of fact about criminal conduct that, if false and published maliciously, can cause genuine reputational harm. Every democratic society balances free expression against protection from defamation. Nigeria's legal framework provides that balance. Sowore's case is its test, not its perversion. That is the prosecution's strongest argument. Misconceptions in public discourse. 1. Sowore is being prosecuted for having an opinion about Tinubu. More precisely, he is being prosecuted for a specific published statement characterizing Tinubu as a criminal, a statement of alleged fact, not merely an opinion. The legal distinction between opinion and fact matters for how a truth defense would be structured and for what the court is actually required to adjudicate. 2. Bail being granted means he is free. Not yet. Bail granted but not perfected leaves the defendant in custody until all conditions are met. Finding a traditional ruler willing to stand surety, meeting the N200 million bond, and processing the passport surrender are all conditions precedent to actual release. He could remain in Kuje for days or weeks while these are being arranged. 3. This is only about Sowore. It is also about Section 24 of the Cybercrime Act, about the scope of defamation law as applied to political expression, and about the template this prosecution is establishing for how future governments can respond to critical online speech. Sowore is the current defendant, the legal precedent being set out lasts him. Nigeria's core national interest in this case is in the answer to one question. Does Section 24 of the Cybercrime Act, as applied to political expression online, survive constitutional scrutiny under Section 39's guarantee of free expression, or does it not? That question has not been answered definitively by any Nigerian court at the appellate level. The Sowore prosecution will generate an answer, eventually through the appellate process, and that answer will determine whether Nigeria's internet freedom environment is in law consistent with its constitutional commitments, or whether online political speech in Nigeria operates under a statutory threat that the Constitution did not intend and cannot sustain. For the Southwest specifically, whose civic and journalistic culture has historically been among the most vibrant and most critical of federal power in Nigeria, a Section 24 regime that can prosecute political opinion online is a direct threat to the institutional culture that Southwest political credibility is built on. The independent journalism, the civic commentary, the online political debate that flows through Southwest communities, all of it sits within the legal perimeter that the Sowore prosecution is currently drawing. Whether Southwest legal and civic institutions actively contest that perimeter or passively accept it is the specific regional accountability question this twist generates.
The long-term significance of the Sowore bail conditions is not what happens to Sowore personally. It is the answer to the question his prosecution has forced into the public domain. What can a Nigerian legally say about their president on the internet? If Section 24 stands as applied here, the answer is less than most Nigerians currently assume. If it is successfully challenged constitutionally, the answer is as much as Section 39 protects, which is quite a lot. That constitutional contest, the real substance under the bail mechanics drama, is the most consequential legal question in Nigeria's digital public sphere in 2026. And it will be settled not in a single ruling on bail conditions, but in the accumulated pressure of legal challenges, international attention, civic mobilization, and eventually an appellate court willing to answer it definitively. We opened with a simple arithmetic: 200 million naira, one traditional ruler, one FCT property owner, one surrendered passport, all for a social media post. The question this video has been building toward is not whether those conditions are outrageous. The Take It Back movement made that case immediately, and the proportionality argument is clear. The question is what the conditions are designed to accomplish, and the answer this analysis delivers is not to ensure Sowore's appearance at trial, which could be achieved with far less, but to achieve, through judicial process, a sustained disruption of his civic and journalistic activity that a detention order without charges could not achieve without worse international optics. That is not a conspiracy theory. It is the most coherent explanation for why a case about his social media post, prosecuted by a national intelligence agency with a jail sentence possible under a cybercrime statute, has consumed this much institutional energy on bail mechanics rather than rushing to the evidentiary phase where the truth of the specific characterization would need to be addressed.
Nigeria's democratic institutions, the courts, the bar, the civil society, the press, are being tested by this case in ways that will outlast Sowore's specific situation. Drop your analysis in the comments. Is Section 24 of the Cybercrime Act a legitimate tool for protecting public figures from false statements, or is it a constitutional threat to political speech online? And do you think any Nigerian court will answer that question definitively before 2027? If this analysis gave you clarity, share it with one person who needs to understand what's really happening. Like, subscribe, and I'll see you in the next one.